All right, welcome everybody. Let's go ahead and get started. Nanaya, can we go to the next slide, please? All right, so welcome everybody. My name is Natalie. I'm a staff attorney with Legal Services for Prisoners with Children. Legal Services for Prisoners with Children is a state bar qualified support center that assists civil legal service providers across California to better support clients and communities impacted by the criminal, legal, and family policing systems. We offer substantive experience, legal training, technical assistance, and policy, administrative, and litigation to support to release incarcerated people, restore human and civil rights, and reunify families and communities. I'm joined by two co-presenters today, Marie Claire and Takwa. I'll pass it over them to introduce themselves.
Hi, everyone. It's nice to be here today. I'm Marie Claire Tran-Leung. I use she, her pronouns, and I am a senior staff attorney at the National Housing Law Project. And I will pass it to Takwa.
Peace and blessings to you all. My name is Takwa Bonner, and I'm the housing advocate of All of Us or None, which is a project of legal services for prisoners with children.
And I also wanted to introduce our lovely senior staff attorney, Nanaya, who will be doing some of our tech work and facilitating some of the breakout rooms and questions and answers at the end of the presentation. And thank you to LAAC for hosting this presentation as well. So this presentation is the second part in a three-part series on disparate impact and how the legal theory can be used by advocates to protect the rights of people with criminal records in employment and housing contexts. The first training focused on the history, development, and current status of federal law on the topic. Today, Marie Claire will give a deeper dive into federal anti-discrimination policy as it impacts people with arrests or criminal histories before turning to protections in California state law and local fair chance housing ordinances. Taka will then discuss the history of fair chance housing ordinances in Berkeley and Oakland and describe organizing strategies to sift local policies. We'll end with an exercise to give you all a chance to apply some of the advocacy strategies and tools discussed in this training. So the goals of this training are to identify housing discrimination protections in federal, state, and local laws for people with criminal records, to learn how effective organizing can help build the power of directly impacted communities to push for durable shifts in policy, using those fair chance housing ordinances in Berkeley and Oakland as examples, and build familiarity with advocacy tools and strategies to improve access to housing for directly impacted community members, including letters for reconsideration and civil rights department complaints. Next slide. All right, I'll pass it over to you, Marie Claire.
Great. Thank you so much. We can move to the next slide and then the next one and then the next one. So I'm gonna, as Natalie mentioned, I'm gonna go over three things today. One is sort of the state of play at the federal level. The second is California protections under FEHA and its implementing regulations. And then the last is touch upon the ordinances in California. So just to start off with the federal level, one thing I just want to kind of make sure folks I know understand have seen this, but in a lot of ways, the administration is trying to eliminate disparate impact, and they're trying to do it in a few ways. One is we've seen executive orders come out to try to eliminate disparate impact. We've seen HUD recently issue a proposed rule that would rescind the disparate impact rule that was promulgated in 2013. We've also seen letters from HUD talking about disparate impact no longer being a viable theory. But I just want to emphasize, number one, that I just want to emphasize mostly that HUD, the administration and HUD cannot simply rewrite statutes. That's the job of Congress, and it can't overturn cases. That's the job of the judiciary and the Supreme Court. And so I feel like that's an important place to start because right now we've been in an environment where the administration has put out a lot of misinformation, hoping that people will adjust their behavior. And this is no different in the disparate impact space. But the fact of the matter is, disparate impact remains good law. And it comes from the Fair Housing Act, and it also comes from decades and decades of case law, including the Inclusive Communities case at the Supreme Court that was decided back in 2015, and other cases that remain good case law in the Ninth Circuit. So I just really wanted to sort of put an emphasis on that. A lot of our work in the criminal history space relies on this idea of disparate impact. And luckily in California, we have a lot of other good laws that help us to make this the promise of the disparate impact theory under the Fair Housing Act become true for us in the state. But I also just don't want to lose sight of the fact that the disparate impact continues to be good law. It just isn't something that this administration is really in favor of. And then we can move to the next slide. So the things that the administration does have control over that they have done is to rescind guidance documents. So the two guidance documents that are really relevant in this area is the 2016 guidance from HUD around the use of criminal history records in housing, and then a follow-up memo in 2022 from the Office of Fair Housing and Equal Opportunity. And HUD has rescinded those guidances, but I think one of our major takeaway messages is that even though they took away those guidances, the underlying legal analysis within those guidance is still very sound because those analyses are grounded in the case law that again remain good law. So even though it's probably harder to take the guidance, a copy of the guidance, and give it to a housing provider and say they should listen to this. For lawyers making their arguments, I think it's really important to understand like what the underlying case law or what the underlying legal analysis is, because it informs the legal analysis that goes under California. And also, I think a lot of housing providers understand that this whiplash between, one legal analysis of the Fair Housing Act under one administration differing so much to another administration is actually not good for business. It causes too much chaos. And so I think there's an understanding from a lot of housing providers that just because this administration doesn't subscribe to this analysis, the analysis is still good under law. So we'll walk through that in a second. The other thing I also want to note is that so I think this is relevant for advocacy to housing providers. If you're talking to housing providers sort of one-on-one on behalf of a client, if for some reason you're thinking about doing a case, I would highly recommend before you do that to consult with some fair housing experts, because there is, always the potential of sort of making bad case law in the fair housing space, especially under disparate impact theory. And we are very happy to sort of connect you to some of those experts to talk through cases before they're filed in federal court. So we can move on to the next slide. This is a lot of this is review, and Natalie, I think, went over a lot of this in the last webinar, but just to remember, under the Fair Housing Act, criminal records is not a protected class, but adverse actions can still violate the Fair Housing Act. And this is really under a couple theories. Number one is discriminatory treatment. So this is where there's intentional discrimination. And we always try to emphasize that with folks because sometimes there are instances where housing providers are applying criminal records policies differently because of somebody's race, because of somebody's national origin, because of somebody's sex. And being able to identify that is actually a much straightforward case and still very much a viable claim under the Fair Housing Act. And then the second is obviously the disparate impact theory, which we'll go into a little bit more. Next slide, please. So the next few slides is really just to show again that there is a burden shifting framework for the Fair Housing Act. And that first it starts with the plaintiffs. It starts with a plaintiff's burden to show that there's a discriminatory effect. And then it shifts over to the defendant's burden to show that there is justification. And so I don't want to go through all of that now because I think it'll be relevant mostly for the California discussion. So maybe let's, if we can skip ahead a little bit to the next slide. So a couple things from the 2016 guidance that I do want to pull out because I think it's still relevant today is there are some really general principles that apply regardless of whether you're kind of filing under the federal Fair Housing Act or under FEHA. One is that any sort of policy that has arrest without convictions is going to be suspicious under the Fair Housing Act because it offers really no proof of underlying criminal activity. It just offers proof that someone was suspected of criminal activity. So if you see that, that should raise some flags. The other is that there shouldn't be any sort of blanket bans on convictions. And this is specifically called out in the California laws. And that's because there's no sort of nuance or narrow tailoring to indicate risk to resident safety and or property. And then the last big picture principle is that even if there's a policy that only looks at some convictions, housing providers have to show that there's a demonstrable risk to resident safety and or property. And that's usually by showing that the housing provider considered a few factors. One is the nature, severity, and the recency of the underlying activity. And again, all of this is spelled out in the 2016 guidance, which may not be something that you can just hand over to a housing provider, but can really inform the analysis that you do when you're advocating on behalf of clients, and is also very relevant to the California analysis as well. So we'll move ahead to the next slide. And then here also individualized assessment and the opportunity to provide mitigating factors is a really important way to a really important less discriminatory alternative to blanket bans. Next slide. So the other thing I also wanted to make sure to point out that is still relevant in the fair housing context is that the Fair Housing Act does have an exception for the use of disparate impact theory for convictions for manufacturing and distribution of drugs. There's advocacy to try to remove this provision called that folks are calling the Thurman Amendment that is going on in Congress. But for now, this still exists in the Fair Housing Act. The reason why I want to mention this is because this is a really important place where state laws and local fair chance housing ordinances can help fill in this gap for protections. And because it impacts a lot of people, we want to make sure to kind of highlight that. Next slide, please. And then the other thing I also want to know, we've talked a little bit about the 2016 memo, but what I do want to note about the 2022 memo is that it really sort of expanded the scope of the application of the Fair Housing Act to tenant screening companies as well, which I think is also a significant expansion of the scope of the law. And again, California law also applies to tenant screening companies as well. Next slide, please. Thank you. And then the other thing I want to make sure folks sort of know or remember under the Fair Housing Act and other civil rights laws is that there's the ability to request reasonable accommodations, um, and this includes people who are recovering from addiction and have successfully or are undergoing substance abuse treatment. And this can be a really important fair housing protection for folks as they're trying to access housing. Next slide, please. So we'll move to the California and local fair housing protections. Next slide. And here, I think what I want to kind of note is that while we may not be relying as much on a day-to-day basis on the Fair Housing Act in court, California has very strong laws that recognize disparate impact and generally, and that also recognize how the use of criminal history records can create fair housing concerns as well. And so, again, similar to the Fair Housing Act, FEHA does not ban the use of criminal records in housing generally, but they do place significant limits. And there are three liability theories under FEHA. One is discriminatory effect, which is similar to disparate impact, where a policy has a discriminatory effect without a legally sufficient justification. The second is intentional discrimination, where the housing provider uses a criminal record policy to intentionally discriminate on the basis of a protected class. The third is around discriminatory statements, which is where the housing provider uses advertisements, such as saying that they would allow no one with a felony record or anyone with or a statement that indicates a blanket ban. And then the last is improper use of criminal records. So that's where a housing provider would use a non-conviction record like an arrest or deferred judgment or an expunged or sealed record that is exempt under the law. Next slide, please. So again, under the discriminatory effects, similar burden shifting framework to the Fair Housing Act, where the complainant proves that their practice has discriminatory effects, and then the complainant has to provide a legally sufficient justification. And some of the ways that housing providers can try to avoid this sort of liability is to make sure they conduct an individualized assessment. They provide individuals with notice and opportunity to provide mitigating evidence in writing. They give people the opportunity to challenge inaccurate records, and they provide a person with a copy of the policy upon request. Next slide. Individualized assessment here, similar to under the guidance, you're looking at, is there a relationship between the crime or the underlying offense and the person's interest or the housing provider's interest? What is the nature and severity of the offense? And then the amount of time that has happened since the offense. Next slide. And then is the housing provider considering mitigating evidence? So that could be the mitigating evidence helps to show the circumstances that may have changed. So that could be whether it's connected to somebody, there's a difference in age, whether it arises from a person's status as a survivor of gender-based violence, or whether there's health-related issues. Helps to kind of paint the fuller picture of what happened. And then there's rehabilitation evidence that could be offered. So just kind of trying to paint a fuller picture so that a person is more than the four corners of the criminal background check that they're providing. Next slide. And again, this is a list of the unlawful uses that the California FEHA discusses. So anything that's really a non-conviction should not be used to deny folks housing, and then housing providers should not provide blanket bans. And then that is kind of wraps up the FIHA discussion. The other thing I just want to note here is that there are great fair chance housing ordinances in California that provide even more protections than the state. And Berkeley and Oakland in particular stand out because they are more protective than the HUD guidance and the FIHA regulations in that they really deny or they prohibit housing providers from taking adverse action based on pretty much any criminal record, which is, I think, a really important, probably some of the most progressive laws in the country in this area. And so to kind of lead us into some of the discussion around those protections, I want to hand it off to my co-panelist, Takwa, to talk a little bit more about that.
Thank you very much. Once again, my name is Takwa Bonner, and I'm the housing advocate for All of Us or None, which is a project of legal services for prisoners with children. Can we please go to the next slide? So after serving 30 years and 2 months straight in the California prison system, when I was paroled to a mandatory 3-month stay in a transitional facility. Within 2 months of me being back into society, I gained employment, which made the 3 months go by real fast. Now, please keep this in mind. How in the world is 3 months going to stabilize an individual after serving 30 years in prison? Thank God for legal services for prisoner children, and All of Us or None. Nonetheless, coming back to the transitional facility one day from work, I was informed that my 3 months was up and I had to get out. Fortunately for me, that a preacher in Oakland gave me a Toyota Camry. And that's when I collected all my belongings from the transitional facility and I packed them inside my trunk of the car. I moved in with my youngest sister until someone informed me that I was putting her housing at jeopardy because she has a Section 8 voucher and she lived in a Section 8 unit. Prior to 2020, the housing laws for Section 8 and housing authority states that anyone who's been convicted of a felony could not live on a premise. If I was caught living in my sister's unit, she would have not only lost her Section 8 voucher, but she would have got kicked out her unit. So I removed myself from her home. Both my sisters and my daughter are all three on Section 8. So I couldn't live with any one of them. So I moved in with my mom. And before I went to prison, I couldn't read or write. So I learned how to read and write in prison. And so now I'm home with my mom and I'm helping her to renew her lease. Very excited about this. And while helping her renew her lease, I discovered that part of her leasing agreement states this: although she lives in a privately owned apartment complex, her leasing agreement stated that anyone who'd been convicted of a felony cannot live on the premise. So for the first time in my life as an adult, I had to lie to my mother, which I'm not proud of. I would come from work, visit with her, eat with her. I would shower in her home, and I would tell her, "Mom, I found me an apartment. I love you, and I will see you later." And I would get in my car and I would park 3 or 4 blocks up from her home, and that's where I slept for the next 6 or 7 months. Now I did apply for a apartment complex in San Leandro. I stood in line. I stood in line all morning. I filled out the application, and on the application, it asked me, "Have I been convicted of a felony?" And I marked the box yes, not realizing that I screened myself out, never to hear from them again. I then got connected with a property manager. Called the individual on the phone. I told them, "Hey, I've been convicted of a felony. I need a place to live." They said, "It's no problem. It's okay." right? Come in for an in-person interview. So I went down there, and this place was in Brentwood. I went down to Brentwood. I paid $25 to get my application processed. At the time, I told him again, I've been convicted of a felony. He said, no problem. 6 months later, they contacted me and said, unfortunately, anyone who's been convicted of a felony cannot live on the premise. Next slide, please. And so, what those current laws have done to me, what it forced me into homelessness. As I stated, I was sleeping in my vehicle for 6 to 7 months. I was sneaking in and out of my girlfriend's apartment, surf couching on family members' couches. Um, and then while at work, I became very depressed. And I did what I was trained to do in prison, which was if you fall into depression, contact a member of your relapse prevention team. And I did just that. I called an individual from my team. I told him how I was feeling, my living situations. And maybe a day or two later, I received a mysterious phone call from a gentleman and was telling me that he was going to bail me out and he started explaining a lot of things to me. And at the end of the phone call, he said, by the way, my name is Dorsey Nunn. He said, consider this, you passed the first portion of this interview. He said, come in tomorrow for an in-person interview so we can hire you. And so instead of going to my regular job at Tesla, I went to visit Mr. Dorsey. Um, and at that office in San Francisco on Market Street, that's when I met Hamdia and Tina Nunn. And after the interview, they hired me on the spot. And and Dorsey Nunn asked me exactly what I wanted to do. And I told him, I'm just one amongst thousands of men and women who are being forced into homelessness, and we have to stop this. Um, and then he had connected me to uh, Just Cities. Next slide, please. And so when I got to Just Cities, the first thing, Margaretta Lynn, she is the CEO of Just Cities at the time. The first thing she did was she organized us. When I mean us, those who've been directly impacted by the housing laws, she organized us. And we had, as you see on the picture, we have a mother um, who had to tell her son he couldn't live with us, her and his and her son, her grandson. We have another grandmother who had to tell her grandson, you can't come live with me because I'm on Section 8, right? You have a father back there. He had his two young children with him, and he was sleeping in somebody's basement. And you could tell and the guy in the back, he's a very tall gentleman. So he spent the most of his time bent over in someone's basement. Um, the first thing that Margaretta Lynn did was to organize us on how to tell our stories. And I'll tell you why this is so important. It was very embarrassing for me to tell folks that I've been in prison for 30 years. And it was more embarrassing for me to tell the public that I was homeless, sleeping in my vehicle. Um, but she gave me the training that I needed to tell my story without me getting overly emotional. And what was so important about us telling our story is that we humanize the situation. Folks that's in authority, they're used to numbers, they're used to statistics. And so when we came and told our personal stories, it humanized the situation quickly. For example, we was in the mayor office in Oakland. The standing mayor at the time was Larry Reed. And he gave me permission to tell this story. And as I was telling him my story, he stopped me and said, excuse me, son. He said, you've been in prison for 30 years straight? And I said, yes, sir. And I continued telling my story. And then he stopped me again. He said, hold it. He said, currently, my son is in prison. And you mean to tell me when my son get out of prison, he can't live nowhere in California? And I was like, absolutely correct. And he was like, that's some BS. We have to change this crap. And so Oakland was the first to pass the fair chance housing laws, and then followed behind Berkeley. And when we got to Berkeley and in the mayor office, the mayor at the time was Jesse Aragon. I'm not, I tore his last name up. However, when when Jesse heard about our story, he said, "This is not fair." And so the people of Berkeley got together and threatened the mayor and said, if you pass this fair chance housing law, we're going to uproot you from your seat. And so Fair Chance Housing, the coalition got together and we defended the mayor. And we put on a town hall meeting and we invited all the members of the community to sit down and talk about it. And so we educated the public on exactly what does the Fair Chance Housing Law does. And in doing so, one of our biggest adversary, she stopped the meeting and she said, I have to confess. She said, my family's house was in jeopardy. And the only way my grandmother saved our house is we had to rent out our home to formerly incarcerated individuals. And she became our biggest champion. And then Berkeley passed the fair chance housing laws. And my point is, this is why it's so important to tell your story and to get organized in this work. Next slide, please. Again, Berkeley landlord, the president of Berkeley Landlord Association became our biggest champion. And I have to tell this story because when we was in Berkeley, one of the women that's in the coalition, her name is Miss Sherry, and we was in the office of the mayor, and she was telling folks how she had to turn her son away. And one of his chief of staff had to tap her on the shoulder and explain to her that her son was just murdered. Her son was like me. He came home from prison and he tried to move in with her. And she said, you can't live with me, son. We both would be homeless. Just like me, he couldn't find a place to live. So he moved down to Southern California where he found an apartment. And 2 weeks later, he was murdered. Someone said that he was playing his music too loud and murdered him. And now when she tell her story, she said, had my son been able to live with me, he would be living right now today. Next slide, please. So the origination of fair chance housing laws originated in Seattle. Seattle passed the fair chance housing laws, and then San Francisco passed a similar fair chance housing law, and then Richmond passed a similar fair chance housing law. And the fair chance housing law of Alameda County, what we did was we took from Seattle, we took from San Francisco, and we took from Richmond, and we learned their downfalls and we learned their strong suits, and then that's how we put together the fair chance housing laws. And in organizing, Margaretta didn't only organize us, but she trained us on the fair chance housing laws of Seattle, San Francisco, and Richmond, and put us out front as political outreach leaders for this campaign. And at the very moment, the county of Alameda is in fear of passing the fair chance housing law throughout all the cities in Alameda due to Seattle being sued. Now, one of the main reason, or the main reason why Seattle was sued is because Seattle passed the fair chance housing laws and didn't consult with the people, which violated a lot of landlords' due rights. And the difference between Seattle and Oakland and Berkeley's fair chance housing laws is that it started with those directly impacted. And then we organized it and took it to the people of the city of Oakland and Berkeley. And then we took it to those that was in authorities, the city council members, board of supervisors. And then that's when it was passed. And so that's how the fair chance housing in both in Berkeley and Oakland originated. Next slide, please. So here we at this very pivotal moment where the Board of Supervisors is saying they want to take a second look at the fair chance housing. Uh, we won the first reading of the Board of Supervisors, and then during the second reading, two of our champions passed away, which is Richard Vias and Wilma Chan. And then Fair Chance Housing died at that moment. Now we're bringing it back. Now the Board of Supervisors is on board. Um, and so what I'm going to ask for is a call to action. If you know those who have been directly impacted by these housing laws, please have them contact me. And my contact information is on the bottom. It's talkwithprisonswithchildren.org. Um, and for those who would like to get involved and help us, you can visit our website or contact me personally. And with that, I'll turn it over to Natalie.
Thank you, Takwa and Marie Claire. So can we go to the next slide? Thanks. Yeah, so now I just want to give everyone an opportunity to try to kind of put some of these tools that they've learned about in action through an advocacy exercise. So we'll go through like a hypothetical situation and then have you all break out into some breakout groups to kind of discuss some discussion questions and think about how you would approach this issue. So let's go to the next slide. All right. So the fact pattern, I'll just read this out. Carlos is a 32-year-old Black man who came home in 2023 from spending 3 years in a California state prison. Since coming home, he's lived with his sister, her husband, and their 3 kids in Sacramento. Carlos and his wife are expecting a child and are looking to rent their own apartment in the same area. In March 2026, they applied for a unit in a large privately owned apartment complex, and Carlos consented to a criminal background screening through RentSpree as part of the application process. Shortly after, the landlord sent Carlos an email saying that his family's application was denied because he does not meet the tenant qualifications. The landlord attached a copy of his background report with the letter. On the report, Carlos sees green checks next to the words credit, income, and eviction history. He sees a red X marked next to the word criminal history. Carlos's criminal record consists of 1 felony level DUI conviction from March 2020, as well as a misdemeanor level DUI from January 2020 and a reckless driving conviction from October 2019. All right, so the discussion questions. What questions would you ask Carlos to inform your advocacy strategy? What preliminary advice would you give Carlos in your first meeting? And how would your advocacy approach change if Carlos were applying in Oakland instead of in Sacramento? All right, I hope you all had a good discussion. Let's go to the next slide. All right, so what are some of the preliminary questions that folks thought they would ask Carlos? I'll ask a couple of you to raise your hands and just we'll come off mute. Any volunteers? All right, Sam, go for it.
Okay, so in our group, and we kind of had an insider group, which maybe is unfair, but we were wondering about if Carlos had preserved any documentation related to potentially consenting to any background check or what the actual rental application looked like, and asking him if he had any copies of that so we could make sure if there were any future deadlines or any other ways that he could contest the denial, we could help be on top of that.
Great. Any other groups have ideas of questions that they'd ask Carlos?
So I'm going to put our breakout room on the spot. So I'm gonna ask Manny to come forth and discuss what we discussed it a little bit. I'm gonna put him on the spot right now. We kind of went outside the box, but it wasn't very important. So Manny, if you may, please.
No, yeah, no worries, no worries. Yeah, unfortunately, I just kind of took advantage to be in the room with Takwa So we at Fire, we're actually working on trying to reproduce the Ban the Box initiative that was already done in Oakland and Berkeley, but down in Orange County, and then use that to leverage it to Los Angeles. And also already spent the entire beginning of this year contacting just about every single legislative office in California to try to get a bill on Ban the Box housing. And unfortunately was told no by well over 100 offices. But we were able to get certain questions from some of the legislative offices that I thought was interesting. We were told that there was a report out that made it seem that Ban the Box housing actually had unintended consequences, and that there was a lot of lobbyists in the real estate field who were using that report as their like, "Ha, we got you. Don't do this because it doesn't actually work." And so I was wondering and asking Taco if there'd been any conversations around how to challenge that narrative. And then as well as like whether there's any connections we can make here or beyond, because we are interested in pushing the local ordinances to try to leverage for a statewide ordinance bill eventually.
Awesome. Yeah. So there might be some opportunities to see if there were ways to engage organizers in this hypothetical, probably in Sacramento, on this. Crystal, I'll let you also chime in now.
So in looking at that scenario too, and I could be way off with this one, but because he consented to the background check, I was just wondering, did they ask him, did the landlord actually provide him a written screening criteria before he had even applied?
Yeah, I think that's a great question. Did they provide him with the record screening policy? I think that's also a very good question, and something that folks should definitely be asking for in these sorts of circumstances. Nanai, can you pop up the rest of the pieces of this? So some other things folks might want to ask him are what his goals are, if the report seems accurate, if he's already requested an individualized assessment for his application with the landlord, and any documentation of that. So requesting an individualized assessment, some of the other things you might want to ask him, because if you remember from the earlier parts of the presentation, the part of that assessment is to show that the housing provider has to show that the conviction history is like directly related to a substantial and non-discriminatory interest, right? So you could try to make some arguments around the nature, recency, and severity of his convictions, right? They're DUIs, so those aren't probably that related to his ability to be a good tenant. So that's one sort of argument. You could look for changes in circumstances. So asking him kind of how his life has changed since the time that he got those convictions. If he's done any sort of like substance use treatment, and what his employment is like now, to show that like, he has stable means of paying the rent. Like his background check said that his income was fine. So this is another argument you could make. Next, yes, and prior tenant history. So something you could include in like an individualized assessment is things like substance use treatment completion certifications, getting good letters from his prior landlords. It seemed like he lived with his sister, so maybe he had a good relationship with that landlord as well. Okay, let's go to the next one. So I just want to run through this real quick because we're almost at time. So in Sacramento, an advocacy strategy could, let's click them all up. He could submit a request for an individualized assessment, could consider submitting a complaint to the Civil Rights Department, or look for opportunities to engage organizers to shift policy. Nanaya, can you click the request link under Sacramento? So we're going to share this toolkit out with with everyone participating in the call today. So this is a template advocacy letter you could use with a housing provider if this sort of situation came up. So you can just scroll down. You can see there's spots for the person to fill in the information about their application and their request and what ended up happening. It cites, keep scrolling down to some of the sources of law, the authorities. is something that you can use to try to persuade the landlords. And then if you scroll down a little further, there's also space for the person to put together their mitigating like information packet, essentially. This is something that a landlord or an attorney or advocate could do with someone, or something someone could do on their own as well. Let's go back to the slides. There's also some other toolkits specifically for Oakland and Berkeley, where there are more protective ordinances. I won't go into those now. We're going to link that, but just know that those tools will also be sent out to you. All right, you have a few minutes for questions if anyone has them. And I'm going to drop the toolkit in the chat here. Hakla, are you asking a question?
Yeah, yes. Well, no, I have a comment. I don't have a question. I have a quick comment.
Sure,
And
go ahead.
one thing I failed to state is that when fair chance housing got passed in Oakland and in Berkeley, I was able to obtain a housing lease of my own.
All right, we probably have time for like one question if anyone wants to ask one. And if not, we can just wrap up real quick. Nania, do you want to just close us out?
Yeah, I just want to thank everyone for attending, thanking Natalie, thanking Takwa, thanking Marie for sharing, the information about how folks can get involved. As Natalie says, we have materials that will be sent out by LAAC in the coming weeks, and we have this housing resource and pamphlet that you can use to organize folks, to connect folks with resources. And we're hoping that, as one of the folks said on the call, that this can go from Orange County to LA County to Alameda County to all over California, and really push this as something that should be a right for everybody, a right to housing, regardless of your background, regardless of your circumstances, and nationwide. I think we're going to also, Natalie's going to drop the link to a survey so you can give some feedback about how this presentation went. Any suggestions for next time, and what you like and what are opportunities to grow. And we will be having our final presentation on April 23rd, and that will be covering employment and a fair chance in employment. And then lastly, we are having Advocacy Day called Quest for Democracy from May 2nd to the 4th. And this is also an opportunity to push policies and bills that expand and restore the rights of formerly incarcerated folks and the impacts on their families and communities. So we will have a number of bills. We had a bill that went past a hearing in committee yesterday dealing with climate change and prison conditions. So all of these are related to how people re-enter into society, and the resources and the infrastructure to support people while they're inside and as they come out. And so it's another opportunity to build a community, to build alliance, and to build, again, this statewide and nationwide organizing efforts to ensure that everybody has access to their rights and it's realized. So thank y'all.